So I will introduce our moderator for our next panel, which is patent law. Eric Goldman is the Associate Dean of Research and Professor of Law at Santa Clara University of Law. He will introduce our panelists and we'll follow the same format. We'll have a little bit of time after the panel for questions and comments. Eric.
Yeah, thank you. It's a great honor to be here. Just a brief word about my origin story with Dan. So I met Dan online on an email list back in sometime around 1994.
Of course you did.
Huh?
Of course it would be in line with you.
Well, and it was such a different time because, of course, many of us nowadays meet new people online first. But back in the day, that was actually quite rare. And it was just such a special community where people of like minds were coming to form relationships and exchange views. And of course, you can imagine online, Dan was himself, purified. And so, he definitely stood out. But so, it's been a 30-year connection for me, but some of that started in online context. So some of the previous panel was riffing on the idea that Dan's intellectual veracity and diversity. And some of you may know the analogy about academic hedgehogs and foxes. Hedgehogs are good at one thing, foxes are good at a lot of different things. And the program today actually shows you Dan is an intellectual fox, that he was wide-ranging in his interests. But if you had to pick one and said you had to pigeonhole Dan, you would pigeonhole him as a patent scholar. And to help us understand that literature, we have 5 really great experts, almost who really don't need any introduction among most of us here. But I'll go ahead and do it anyway. We'll start with Rochelle Dreyfuss, who's the Pauline Newman Professor of Law Emeriti at New York University School of Law. We have Sapna Kumar, who is the Henry J. Fletcher Professor of Law at the University of Minnesota School of Law. Sorry, I skipped Tim. We have Tim Holbrook, the Provost Professor, and Robert B. Yege, endowed Distinguished Professor of Law at the Sturm College of Law, University of Denver. We have Mark Lemley, a brother from another mother, I think is perhaps in a way. Some of you may be having kind of these visions of Dan being in the room, who is the William H. Newcomb Professor of Law at Stanford Law School. And finally, we have Siva Thambisetty, I hope I did okay, the Associate Professor of Law at the London School of Economics, Political Science School of Law. I believe we're going in alphabetical order, and that would mean Rochelle, you're up.
Okay, well, so I'm so grateful Mark and Tony provided us with this opportunity to praise Dan, and glad he knew about it and that we all loved him. So he did so much for the field and for all of the people in it. As Julie said, he was the real deal, a wonderful scholar and a true mensch. And I'm going to start with the mensch part. So I had thought until Pam's presentation that the first time we had met was in an early version of the Young Scholars idea, where senior faculty were advising aspiring academics on writing a paper and presenting their work. I had been very apprehensive about this gig because first, it was kind of a new idea to the academy, or maybe it was just new to IP, but I'd never been at one of those before, so I didn't know what it was. And second was the fact that Dan and I were cast as the senior people. By modern standards, we both would have been considered junior, especially Dan, who was at that time at Seton Hall. However, once Stephen Breyer moved to admin law and Ralph Brown retired, there was sort of a vacuum at the top. And a bunch of us got just sucked up into being seniors when we were really pretty junior. So at the event, I kind of stumbled along, basically telling my mentee how I would have written the paper that he wrote on the topic he had chosen. But Dan, who again was even newer to the academy than I was, handled this assignment with much more grace. He was already at work turning commenting on other people's drafts into a fine art. So rather than focus on what he would have done, Dan had figured out what his mentee wanted to say, expressed excitement about that idea, and then offered suggestions on how to rework the paper to say that in the best way possible. So I don't know about his mentee, but I learned a lot from that encounter. Now when I comment, I try to do Dan, and focus on the actual paper and how to make it the best that it can be. Dan was equally gracious when he was at the other end of the senior-junior divide. So I've written a lot of letters of recommendations in my day for students seeking clerkships and jobs and faculty seeking promotions. And annoyingly, many people never tell you whether they got the position you recommended them for or even bother to thank you for having done it. But that was not Dan. Even when he didn't know the identity of the reviewer, he managed to find a way to say thank you anyway. So in the acknowledgments to the piece I'm going to talk about, he has a footnote which reads in part, quote, "My thanks to 2 anonymous reviewers for helpful comments on previous versions of this paper," which I thought was so sweet. But my favorite thing was something he posted on IP Profs not that long ago, a thank you to whoever it was who evaluated his work for his distinguished professorship review. I particularly appreciated that because I evaluated his work that review. And I don't know about the people here at UC know this, but UC asks you for reviews of very specific pieces chosen without any apparent regard for what the recommender herself actually knows. And as we all know, one notable thing about Dan is that he writes in a wide range of fields. And so I was given some stuff to read that I knew absolutely nothing about. So it was a huge amount of work for me. And I really appreciated getting thanks, even if it was that anonymous thanks. So one other reminiscence before I get to the scholarship, this from the 2016 EPIP conference in Oxford. So it featured 2 keynotes, an IP scholar who was me that year, and then an innovation economist who had suggested beforehand that I reserve a few minutes of my time to discuss his presentation. So I wasn't that eager, but okay, I did leave a few minutes, only to realize as he spoke that his paper, which was empirical, was based on a complete failure to understand the patent prosecution process and the information in the patent documents that he was looking at. I had a very hard time keeping my eyeballs from rolling around my head, and I couldn't imagine what I was going to say that wasn't utterly dismissive. Luckily, Dan was in the audience right in my field of vision. And as many have already said, he has no trouble spotting errors in other people's work. And so as the economist spoke, Dan was doing his little moves and the little twitches and the little twinkling of the eye. And so it was really quite a few grimaces. So it was much easier to keep my eyeballs straight looking at him as this guy spoke. And that wasn't even all. Immediately after the presentation, Dan jumped up and asked one of those wonderful questions that demonstrates huge enthusiasm for the project and what it could mean, and that explains in the nicest, most supportive possible way, as things stood, the paper was totally wrong. So I can't begin to say how grateful I was to Dan for being there that evening, because he took up my little extra few minutes and I didn't have to say a word. So with that, on to the scholarship. So here I think of Dan as one of those Arctic icebreaker ships designed to climb on top of the ice, bear down, and crush it, breaking it up so that the vessel can be other people can easily navigate through that stream. It's not surprising. Dan came to patent law with several distinct advantages: clear-headedness, common sense, scientific literacy, and because of his extensive exposure to foreign legal systems, a deal of skepticism about U.S. law. So he was exceptionally good at thinking about whether existing doctrine made sense, be it from the point of view of the science that these doctrines aim to regulate, or from the perspective of the goals that the law sought to accomplish. In addition, and perhaps more importantly, he really knew how to turn a phrase, to crystallize what needed to be said in punchy, memorable sort of bon mots. You could see that even in his posts on IP Profs. They were rarely more than 2 lines long, and yet they cut through all the rhetoric and went straight to the heart of the matter under discussion. After one of those posts, I would often slip him a personal email and said, "Go, Dan." So that capacity for pithiness was also evident in his scholarship. One of his pieces on patentable subject matter, which is still under discussion on IP Profs today, Mark's already busy writing another one, I can see. Furnishes an example. He wrote extensively on the jurisprudence in this area, but my favorite piece is an essay he published in 2015 in the Journal of Law and Biosciences called Dolly and Alice. The piece looked at In re Rosalind Institute, where the Federal Circuit was asked to decide whether the claims to Dolly, a cloned sheep, were patentable. The case required the court to consider the series of Supreme Court cases that started with Bilski and ended eventually with Alice. So that's Dolly and Alice. So in the paper, Dan did several things. First, he called the Supreme Court out on using the same analysis for products of nature, laws of nature, and abstract ideas, and explained why these categories are fundamentally different and pose different sorts of problems. Second, he showed how poorly the cases hung together, how the court in Myriad ignored Mayo, even though it had remanded Myriad for reconsideration in light of Mayo, and how Alice was not, as the Supreme Court claimed, really a summary of what went before. Third, he used the decision about Dolly to illustrate how impossible it is to apply the Supreme Court's approach, or better approaches, to deciding subject matter coherently. To make that point, Dan started with Myriad, which at the time of Rosalind was the controlling precedent. In doing so, he looked not at the hype surrounding Dolly, which was all about she was a carbon copy of her mother. She and her mother were on the cover of Time magazine, showing two identical-looking sheep, so that was all the rhetoric. Dan wasn't impressed. He looked at the science, at the technology that produced Dolly, and at what that technology had actually created, what Dolly actually was. He focused on the transfer of a nucleus from the somatic cell of one sheep to a zygote of a recipient animal. The resulting lamb had the nuclear DNA of the sheep that donated the somatic cell, and in that sense, Dan acknowledged Dolly was indeed a clone of its mother, the donor of the somatic cell. However, because Dolly had the mitochondrial DNA of the recipient, Dolly was in actuality different from any naturally occurring animal. She was, as Dan put it in his pithy way, a sheep with two mothers. Dan also identified another difference between Dolly and a conventionally created sheep. Because her chromosomes were taken from mature somatic cells, they had shortened telomeres, the structures at the end of chromosomes, which appear to be determining longevity. Dolly was, he said, in a genetic sense, born old. Given these differences, two mothers, born old, how, Dan asked, could the Federal Circuit have invalidated the patent on Dolly on the basis of the Supreme Court's decision in Myriad? She wasn't naturally occurring, so the Federal Circuit should not have likened her to genomic DNA. Rather, she was similar to complementary DNA, which the Supreme Court had said was man-made and therefore protectable. The folly of trying to follow Myriad was evident. It's just not clear what is in fact natural and what isn't. And in other articles, Dan provided many more examples of things that were sort of natural and sort of not natural at the same time. Well, what about Alice? Dan next showed that the Federal Circuit would have done no better had it decided the case under Alice's two-step test, which asks whether a claim is drawn to an excluded category, and if so, whether it adds an inventive concept. Again, it would be hard to call the clone a product of nature, given that Dolly and her siblings were the only sheep on the planet, born old with two mothers. But even if you thought Dolly was a product of nature, it would be difficult to say that the effort involved in cloning was not an inventive step. Dan looked at the scientific literature in which that process was actually called a technical breakthrough. The paper, all told, provided a concrete illustration of the indeterminacy of Section 101 jurisprudence, a finding confirmed since by many good empiricists. And Dan's paper did so in a particularly forceful way. It's fun. It's about sheep, two mothers born old. My students love it. Easy to understand and remember. The step-by-step consideration of the case law also allowed both patent and non-patent legal scholars, jurists, and policymakers to grasp the problems. And its granular description of the underlying technologies brought scientists and technologists into the conversation about what the appropriate patent scope actually should be. Most important, the paper demonstrated that there is no way to draw a bright line between what is and isn't eligible for patent protection. Instead, it argued we need to understand that the role that the Supreme Court thinks the subject matter doctrine plays, and then ask what approach would in fact accomplish that goal, much like he did with his mentee way back when. Dan put his conclusion as follows: present law has things backwards. The issue is not what a subject matter exclusion is not that a subject matter exclusion needs to be recognized in order to avoid preemption. It's that preemption needs to be recognized in order to know when to impose a subject matter exclusion. That, he suggested, would vary from situation to situation, depending on the degree to which the claimed invention occupies the field and how much that field can tolerate a degree of private control. He also argued that once one adopts that perspective, other ways to deal with the preemption problem may actually look preferable to a subject matter exclusion. So shades of, I think, the article he and Mark wrote so long ago, and I guess Mark will talk about. In fact, he demonstrated that even some of the precedents that the Supreme Court cited in the Bilski to Alex series was not really about patentable subject matter at all. Dan was most recently at work cutting his way through artificial intelligence and all the rhetorical Arctic ice surrounding it, where he was asking very similar questions about what AI actually is, what it's actually doing, and what it can actually produce. I had wanted to come here to say once again, go Dan. Instead, I'll say, may his memory be for a blessing. But not only for a blessing, but rather as a template on how to be a wonderful colleague, mentor, productive scholar, friend, how to be a real mensch, and how to be a good father also. I want to say this one other thing, which has nothing to do with patent law. One of the interesting things talking to Dan at many of these conferences and afterwards was the pride he took in educating his daughter. She was educated at home, and he took so much pride in watching her develop and learn about the world. And it was just so interesting to watch him do that and to think about how a parent really should act. Yeah.
And thanks to Mark and Tony for organizing this event. It was incredibly thoughtful, and even though not the initial event planned, I think it's great to be in community, to be able to celebrate and mourn together. Thanks UCI for hosting, and my condolences to Dan and his family. But I'm very honored to be able to celebrate Dan's work. I'm honored to be on this panel and humbled to be on this panel with some people who have been important in my scholarly life. When I was thinking about how to approach this, I came up with a theme, got to have a good theme, and it's Dan was there first. No matter what I tried to write, when I thought I'd have something new, Dan was there first. And so I was mentioning this to Mark Janis, and he noted, well, that was literally true for him because he was also on the market apparently around the same time. What a year of market that must have been at that period of time, because everywhere he went, they said, oh, we just talked to Dan Burk, right? So literally, Dan was there first. And so one area that I focused on, unsurprisingly, and Sapna and I share this interest, and we'll share some comments, is on extraterritoriality of intellectual property. And so this gave me the reason and excuse to go back and really mine his Tulane Law Review piece, The Patents in Cyberspace, Territoriality and Infringement on Global Networks. 1993, right? It's a different world. Basically, there's a primer on computer networks, right? There's references to the internet, but it's not all about the internet. There were no search engines back then, so there were open questions about whether things posted on these networks would count as prior art, right? It was, I think most of our students don't realize that world actually ever existed. So to read it back was sort of like a transporting back in time. And this is also before the Supreme Court's recent re-engagement with the presumption against extraterritoriality as well. And so this was not something really on a lot of people's radars, but I think as everyone has explained today, it was on Dan's because he was thinking about these networks as a form of technology, and what are the implications of that technology. Now, this was published before he was even on tenure track, right? This is when he was a visitor at George Mason. So this is very early work, perhaps not a student note, but still pretty early on. And again, it just shows such an incredible academic mind, and as some of the comments on the listservs noted, a prescient mind. So what I'm going to emphasize here is that not only was he foreseeing the transborder implications of the internet, he was also identifying the solutions which actually end up getting adopted by the courts, sadly without attribution, right? And I know that they were aware of his work because he cited in some of the briefs in some of these cases, but it was interesting to watch what he argued map onto particular outcomes in these cases. And so the paper is really a comprehensive assessment of computer networks. He talks about the extraterritorial expansion of U.S. patent law under 271F, the response to Deep South, where exporting components can be infringement, the embrace of 271G, the import of products made by patented processes. He even talks about the floating island approach to temporary presence in the United States, his work on space and inventions in space is in there. And so it's really a comprehensive paper about all things extraterritorial. And he quickly highlighted issues of sovereignty and differences in law, which for anyone who knows my work, so that's sort of my shtick, right? He was there already, and concerns about potential arbitrage of different countries in this area. But what I was really taken aback by was how he just sort of delineated the true patent infringement issues. So he talked about use, right? These are generally going to be viewed as computer software as methods. And so who should be deemed the user of these networks? And so he articulated, well, some measure of control and benefit should be identifying who is the user. That was in 1993. In 2011, in the Centillion case, the Federal Circuit says who is the user of a network. Quote, the customer puts the system as a whole into service, i.e. controls the system and obtains benefit from it. Boom, boom. Now that is, is Centillion's way of dodging the divided infringement problem that we had run into with method claims, but still, it's like that's exactly what he had argued in 1993. He also addressed the extended instrumentalities issue. In other words, when you've got transborder systems, how do you deal with that circumstance? Given that a host computer and the user could be in different countries, he emphasized that there needed to be some U.S. connection, in some ways foreshadowing, I think, our focus test in the modern era. But he noted infringement could easily be viewed as operated or controlled within the United States if portions of the system are projected beyond the U.S. borders. Sorry. So in essence, this is where is the system used? And here comes NTP, the BlackBerry case, right? The use of a claim system under Section 271A is a place at which the system as a whole is put into service, i.e. the place where the control of the system is exercised and the beneficial use of the system obtained. Thank you, Dan. Would have been nice to have a site. Now, of course, as we know, they go completely bonkers and say, well, that doesn't apply to method claims. We're going to treat them completely different for no apparent reason whatsoever. But we see his work coming out. Inducement of infringement under 271B. Now, there have been some district court decisions holding that provision had extraterritorial reach. And he said, look, textually, there's no reason not to provide that protection. Muriel versus Cipla, 2012, Federal Circuit. Inducement has extraterritorial reach. As long as you induce infringement in the United States, activity outside of the United States counts. And then, I imagine Sapna will hit this quite a bit more, he foresaw the potential for data products and whether data products could be imported into the United States under 271G, right? Now, he knew this was a close call. In one paper, he seemed to suggest you should. In his companion piece in the Stanford Law and Policy, he sort of backed away from it a little bit. And in that one, his hesitancy was correct, since the Federal Circuit did go the other way and concluded that these importations of products and patents have to be tangible in some way, both for 271G and for the International Trade Commission. But I was really stunned at how decades before these really came to the fore, he had identified and correctly identified the solutions, doctrinal solutions to these problems. In fact, his concern with sovereignty in the extraterritorial context really stood out as he recognized that there could be concerns. He said he noted that earlier cases that had this nexus to the United States and enforcement of the U.S. patent law outside the U.S. arose, quote, only when the sovereignty of other nations was unlikely to be threatened, right? Foreshadowing Canada's amicus brief in NTP saying, hey, remember us, we're a sovereign nation. The system is in our country too, you may want to remember us, right? So it's just a fascinating read. Now, I did want to pivot a little bit to the personal. When I started as an academic in 2000, there are not many patent academics. At the first IPSC, there were about 16 of us around a table. It's a little different than now. But I never went on the meat market. Right, I was one of the odd ones that sort of slipped into Chicago, Kent, in large part thanks to Christopher Leslie's in the back of the room. I believe in giving thanks as contemporaneously as possible. We were willing to take a chance on some random guy coming off the federal circuit. I knew nothing about the academy. I did not know my work would be sent to outside reviewers, and I knew no one. Some people know, and Christopher definitely knows this, I'd also been out of the closet for 2 years. And so I was also in this space of trying to work on the emotional baggage of being openly gay because I'd made that normative commitment. And it's not easy work, particularly in a very public space. Dan was never somebody who cared in the right way, right? I don't mean to say that he wasn't sensitive to it, but it was just like, man, right? And I would say, and I want to share this, like that was my experience with 99.9% of our people in our field. I can't say 100%, but I can share that story later. But he made me very welcome. And I appreciated so much about his sharp engagement. In fact, it continued just last year in his Patents in Action article in Geometrics when he will happily correct your mistake. He noted in a footnote, it is essential to recognize that such patent-enabling networks are very different creatures than those considered by Professors Janis and Holbrook, who cite to works relying on actor network theory and the apparently mistaken understanding that such networks are communicative networks. To the contrary, such allies may well constitute uncommunicative networks. In any event, they perform an entirely different function. But he cited us. And I will say, he also cited us the same paper later for favorable reasons, right? So the minute we saw that, Mark and I were like, that's Dan. Absolutely, that's Dan. As my husband would say, describing himself, Dan was a swirl of contradictions, right? Intimidating and welcoming, critical and constructive, acerbic and kind. Yet somehow in Dan, this all manifested in a consistent whole. Dan was who he was, and he loved, and he worked, and he was passionate about what he did. In Dan, it all made sense. References made to the AALS concert. That's why I went to AALS. It was usually to hang out with Dan, to find out what was going on, what was the pulse. His legacy is so many of us here, sitting here, impacted by his work, himself as a person. His work will resonate for generations. Dan was there first, and he will continue to be there.
I too am going to talk about Dan's Patents in Cyberspace, Territoriality and Infringement on Global Computer Networks paper. And when I decided I was going to give a talk on this paper, I knew I needed a few images to kind of really illustrate this paper. But I faced a problem, which was any of you who have ever sat next to Dan at a conference know what he thinks about PowerPoint users, right? Like, because inevitably the technology would fail, especially if it was a European conference, because the technology never works in Europe. And first the stare would begin, where Dan would just be like kind of looking at them, like trying to use the power of his mind to get them to just get on with it. And then the snarky comments would begin, usually just loud enough that, you know, the speaker could hear it. And so I realized there could not be PowerPoint. So to introduce the paper, I printed out a poster from the Muppets, Pigs in Space. And so may I present Patents in Cyberspace? Because truly a paper this great needs a great introduction. This was a time when, you know, the internet was very young. We were only 2 years past the beginning of the World Wide Web. And the same year when a not very well-known VAP at George Mason gave us this brilliant paper. And it could have fallen into the same trap that many other papers do when they hype a new technology and then claim it's going to have a profound impact on the law when it really doesn't. Thinking about like the dozens of 3D printing papers from the 2010s. But Dan really accurately predicted this octopus of data, those were his words, that would have this profound impact on territoriality and IP infringement. And he really foresaw these problems that would come up in later years surrounding software and data infringement across borders through the what he called shadowy realm of cyberspace. And he was really the first one to tackle this with regard to patent protection. So I'm going to just first mention a few things that he foresaw. First, he predicted the rise of patent protection for software at a time when the focus was very much on copyright. He saw that it would be a better fit and that this would be the kind of the future for protecting software. And then in part B, he then turned to this issue of territoriality. He pointed out cases like Deep South Packing versus Latrim. That's the famous shrimp deveining case where the manufacturer was selling the do-it-yourself infringement kits for infringers to use abroad, which led to the Patent Act getting amended. And he talked about how that was the rare example where the courts were being more mindful about territorial limits. But he had this fear that, future courts wouldn't necessarily think so carefully. They might just extend U.S. law without really thinking. And so he raised kind of he raised a number of these problems with regard to how the internet makes it easy for different countries' laws to come into conflict. And, how do we determine what constitutes use in the United States? How do we deal with importation of data with respect to the Patent Act and also with respect to the Tariff Act? And here I actually have to give a little bit of an aside story, which was when I first encountered this paper, it was because I was at the meat market and I did a preliminary interview with UC Irvine. And I think we had about exactly 2 minutes of pleasantry, pleasant conversation. And then Dan immediately started grilling me about my job talk paper, which was on the International Trade Commission. And he so thoroughly knew all the ins and outs of this agency, which, even by patent standards at the time was a pretty obscure agency. And so after this 15-minute thorough roto-rooting of my paper, when I finally emerged from the interview, I'm like, who is this? And I came across this paper where he had talked about the ITC and the Tariff Act and how the internet is one day going to cause problems. And in this paper, Dan really gives all these examples of the issues that are going to arise. He talked about how companies may take advantage of territorial dead spots, how they may try to set up offshore data centers or the like to exploit the fact that no IP law reaches. He talked about the future problems that internet would make patent enforcement risky. And kind of really laid all of this out in 1993. And so this paper, which I discovered after my 15-minute thorough grilling during my interview, ended up having a lot of influence on my future research. So I published a paper called Regulating Digital Trade. And Tim briefly touched on a case, Align versus ClearCorrect, where Align is the manufacturer of these plastic annoying braces that make our teeth look nice. And ClearCorrect was an enterprising infringer looking to get around these patents. And so what they did was they had a Houston dentist who uploaded kind of orthodontic pictures to a Houston-based computer. And then they had an army of dentists in Pakistan that then accessed the data and actually created these treatment plans, which, had they been in the US, would have infringed Align's patents, but they were in Pakistan. And then they put it back onto the Houston server, at which point ClearCorrect would go and 3D print the aligners. And Align claimed the ITC had jurisdiction over intangible data, a position I argued against and that the Federal Circuit ultimately rejected. And here I really have to talk about, Dan's predictive ability. So, like, we think about Nostradamus, right? Like, like the people with the great, vision of the future. But, like, I really posit we should be thinking of Dan because, like, he really had this spot on 20 years earlier. He noted that computer networks would make it harder with regard to figuring out where the clear boundaries of US law ended. The fact that people would try to exploit this, would try to take advantage of this fact. And while he didn't discuss the ITC's jurisdictional authority with regard to digital goods per se, he did broadly predict that the ITC would actually be playing a pretty fundamental role in these sticky questions of territoriality and data. The second paper that I want to mention that was very heavily influenced from Dan's work was with regard to the presumption against extraterritoriality. This issue came up in Western GECO versus Ion Geophysical. This was a case where the patent holder, Western GECO, held patents on these streamers that, like, a ship would drag them, and then they could map the ocean floor. They were used by oil and gas companies. And Ion Geophysical violated 271 F1 and F2 when they exported components for these streamers, sold it abroad, and then it allowed people to assemble the streamers and, outcompete Western GECO. So this case got litigated, and the big issue was that most of the damages accrued in the high seas, which is a dead zone with regard to IP law. Technically, nothing reaches it. And academics were divided in terms of, well, how far should U.S. law reach? To what extent should we let U.S. law, capture that? And here, again, Dan had accurately predicted this. He had talked about the potential for offshore patent havens, and how companies would try to exploit this. And he had noted that there would be these problems with regard to national sovereignty, how U.S. law could come into conflict with other legal systems, how there'd be a risk of the U.S. potentially bullying other countries or trying to influence what their patent systems say. And although Western GECO didn't involve software, the issues that Dan highlighted really came to pass, with the company taking advantage of, international waters in a sense, to be able to escape some amount of liability or attempting to. And again, like, I have to put this picture out because, like, Dan foresaw all of this. Like, he really, like, laid all of these things out. And so, like, 30 years later, after this paper was published, like, it still influences my work. And, like, it still is a reminder of just, like, what a powerful mind that Dan had, and just, like, how these things that, that he wrote just as a VAP, like, influence scholars today. So, yeah, I mean, I can't, I can't say enough just, like, how much his work has really played just an impact in my life, and just him as a mentor. And yeah, I'm just going to stop there. Thank you.
All right, so we have a tendency of people giving lovely talks and then choking up at the very end. I'm a little more avant-garde than that, so there's no way I make it to the end before choking up. I've been practicing. Speaking while crying over the last week a lot, and still a work in progress. All right, so as many of you heard, as you've heard from many people, right? A lot of us kind of came together in the early mid-1990s around the Siberia listserv. I think at the time, 5 or 6 of us doing internet law as academics bonded with the small number of people who were actually practicing law and thinking about it. This was a time when publishing a law review article was sort of like news that would be discussed on the listserv for quite a lot. Someone has written something in this field. If there was a case, it occasioned an enormous amount of discussion. You've heard, I think, a lot already, both from the Internet Law panel and from folks talking about sort of how early Dan's work was in Internet law as a whole, but also really the first person to think about sort of patents in the Internet and how those things would overlap. This was important work. It was, as you've heard, in many ways, prescient work. From my perspective, it was most important because it got both Dan and I invited to a very serious, deep and meaningful conference in the Cayman Islands in 1998, organized by a number of Caribbean countries who wanted to be data havens. And so they said, the thing is, let's invite all the internet people, experts, and there were like, I don't know, maybe 8 of us at the time, right, to come tell us how we can sort of be data havens. The upshot of the conference, by the way, which I think was also prescient, was, you could probably get away with online gambling, even though it's illegal under US law, but do not touch intellectual property. They will come for you if you touch intellectual property. But during the course of this extremely serious conference that was not at all a junket, Dan and I were on a yacht looking at manta rays, where, as one does, we began talking about the patent system. And in particular about the sort of different ways that different technologies experienced the patent system. Dan, having brought both a biotech and a software background, and I having done a lot of work in the software and internet space, just sort of brought these ideas that people were talking about and experiencing the patent system very differently in different industries. And that led to the sort of first tranche of our work together, a paper called Is Patent Law Technology Specific in 2002, the Policy Levers paper in 2003, and then ultimately a book called The Patent Crisis and How the Courts Can Solve It, where we basically said, you know what? Different industries have different needs. They have different characteristics. They innovate differently, and the patent system both can and to a large extent does take account of it. It's hard to understate how insanely radical that idea was at the time. People hated this. I mean, they wrote entire articles and symposia devoted to the fact that this can't possibly be true. The patent system is an integrated whole. It couldn't possibly work differently in different industries. I think this is actually an example of one we won. I don't think anybody would seriously contend that there are no kind of technology-specific differences in the patent system today, right? You could argue about what they should be, how the law should react to it, and people do. But this was something that I think was possible for us only because Dan brought sort of deep technological knowledge from multiple different technologies that enabled us to kind of think through these different industries. We did some other work together that I think also was sort of had been successful around sort of more doctrinal issues like inherency. The upshot of all of this for me was also something very different, which is in the 1990s and the 2000s, whether it was an internet law conference or a patent law conference, Dan and I went to a lot of the same conferences. And, Dan and I have kind of similar body structures. It's probably fair to say we had somewhat receding hairlines. And we were in a lot of the same places, and we were even writing together. And so for a period of about 15 years, nobody could tell us apart. And I mean nobody. Like, friends we've known for decades would confuse us. People would confuse us while talking to one of us while wearing a name tag. Family members confused us from time to time. And I'm like, yeah, I get, we certainly look a decent amount alike, right? We write together, we sit on panels together. But he has a beard. Can you not see the beard? So, what can I tell you? We wrote a lot together, right? In the 90s and the 2000s. We did a bunch of work. Still, yeah, we haven't yet persuaded the world on this one, on the sort of brokenness of claim construction and the sort of pathologies of turning over to lawyers the boundary drafting of legal rights. And then sort of Dan, who you've already heard a couple of those episodes of his life, writing in internet law, writing in patent law. We're going to talk about some other of the sort of kind of fields and phases of his life in the afternoon, right? His work on sort of kind of law and sociology, his work on law and gender. Dan's work and mine sort of started to diverge a little bit. Not that we disagreed, we just sort of kind of focused on different things. Dan started moving his patent work more into the sociology of patents. People stopped confusing us for each other. I'd like to think it's because, Dan started doing a bunch of conferences in Europe and conferences on sociology, whereas I was kind of doing more policy, doctrinal, and empirical stuff. We weren't quite as many conferences together. Probably has more to do with the fact that Dan's hairline stopped receding. Mine has fully receded. But we were doppelgangers. Right, for a long time. I also want to note, so as I said, you're going to hear a lot about the different areas, several different areas of Dan's work, right? I just want to kind of briefly mention, and you've gotten a little bit of a sense of that from the audience participation already, that even these kind of 4 different substantive areas are a tiny fraction of what Dan's working on. You heard about copyright and the internet. You heard about copyright and DNA. He's written on the First Amendment. He's done an enormous amount on international and comparative law. He's written about AI. He's written about science, technology, and society. We could have done a panel on each of those things. He's taught at 18 different law schools. Some in the U.S. with permanent jobs, right? But an enormous number of visiting teaching, particularly in Europe. And I think as a result, he's sort of had an incredible influence in a wide variety of areas. I've got his 56-page resume here, which is pretty amazing. So he's moved into this the sociology of patents, the sort of practical on-the-ground application, right? How people use patents in the real world, how they think about them, how they act as objects. But I think that's part of a sort of broader arc of Dan's work, both in patent law and beyond it, that was aimed at giving us a richer understanding of patent law's place in the world, of patents' place in the world, right? Of how it is that these things operate. And you can trace that, I think, to the focus and the emphasis on getting the technology right, and some of the papers we could talk about. You can trace it to the work that he and I did, thinking about, hey, we've got a nominally uniform patent system, but that's not how anybody experiences it. But it flows through to his work on sort of network theory and author theory. It flows through to his work on the sociology of patents. And it also flows through to the very last article, which he finished last week. It's called Patent Semiotics. Even as Dan was very sick, he was going to continue his work. He finished the paper. It's been accepted by the UCI Law Review. He finished it a week ago Monday and said, well, I guess I'm done writing. And then he died. I wish you could have been here to see this. But I will say, I sent him the list of people, and he said in perfect Dan style, I'm gobsmacked that all these people would show up for me. I'm glad we did.
I'm somewhat in disbelief that I'm here. That might be to do with the fact that I flew 12 hours to be here. And I feel like I'm walking on cotton. But also because I'm just so aware of how close-knit this community is and how central Dan was to that community. And I feel really humbled to have been invited to share in that sense of community. So thank you very much for having me here. I've been at the LSE, the London School of Economics, for 20 years, and there hasn't been a single week when I was teaching when I haven't referred to Dan's work. He was always kind, he was always encouraging, he was a willing mentor. When I once wrote to him about a fellowship application that failed, he immediately pinged back, the reply came almost immediately telling me about a grant application that he had just been rejected on. I'm not sure I bought that. Who's rejecting Dan Burk? But I also feel, slightly goosebumpy because of a few things that have been said on the panel that make me feel that maybe Dan did want me to be here. I'm so glad, Rochelle, to hear you say that the Dolly and Alice paper was, it's a really good one, because he invited me to write a response to that. From a European perspective, which I did. And it's the kind of work that I love doing, which is close and methodical and, comparing what's happening in the US with the European Patent Office. And I loved writing it. And I loved, obviously, having been invited by Dan to have written it. And Sapna, you mentioned the High Seas Treaty. I've just come off the back of acting as advisor to the G77 and China group of countries on the treaty negotiations, which finished last March. And I wrote a paper on the principles in the treaty, Article 7, which has a very unusual juxtaposition of freedom of marine scientific research and common heritage of humankind, so a freedom and property, it was accepted in November, and I regret not having sent it to Dan. I was busy. I should immediately have forwarded it to him, and I didn't do that. I've set myself up with quite a big task in the next 10 minutes or so. And I've been wondering how to convey like all of you, how to convey my regard for him, and also to convey to you a little bit about what he meant to me. And in a way, unusually, I want to do that by explaining why I might have had a disagreement with him. And if I can do that in the short time I have, it would, I think, be the best sort of connection to inspiration that I can convey. There was a moment in the pandemic when it seemed like Dan and I had very different perspectives on a critical issue to do with the intellectual property waiver at the WTO. This was challenging, maybe even a little painful, but in a weird way, dissonance on that important question with someone you admire so much is a sign of maturation, perhaps, a sign of having your own view striking out. But it also, for me, precipitated a significant body of work that I hope to publish soon. And I want to spend the next few minutes sort of outlining what that book is about. I'm going to, and also, I hope it'll be testament to my respect for him that it took me 3 years to figure out how I could possibly talk to him about this. So I'm going to skip over the arguments for and against the waiver. The time for that has long passed. Perhaps the differences in our viewpoints is best represented by the short paper that Professor Hilty and co-authors put out from the Max Planck Center, which assumed that the normal incentive reward scenario would still work for the pandemic. And Dan appeared to agree with this paper. Shortly after that, myself, colleagues Luke, Hyo-Kyun, Aisling, Graham Dutfield, we wrote a paper making out what we thought was a reasoned case, legal and political case for the waiver of IP rights to deal with the crisis that was the pandemic. Now, it's estimated with the current modeling that we have that over 50% of deaths in low and middle income countries could have been averted with early or adequate access to vaccines. The delay in the vaccinations led not only to more infections in these countries, but also probably extended the duration of the pandemic globally. So during these years, the very long years of COVID, what I saw and knew gave me reason to believe that vaccine inequity, which I was defining as a scarcity created by underproduction of the vaccines, was entirely predictable. This is what the patent system is meant to do when you have a large collection of countries that have a very great inequality between them. And we've been talking a little bit about the internet. There's a phrase that Stafford Beer coined about the purpose of a system is what it does. And it kind of counters the thinking that we need to think philosophically or politically about what a system does. When a system does what it does, we believe it and we take it at face value. So for me, vaccine inequity seemed to be an expression of how the patent system functions and is really meant to function. So from here, I wanted to sort of talk about a form of structural injustice that I think arises from the patent system. So we're very familiar with the kind of scarcity that allows, that arises when you have a patent on a technology. It allows you to value that good, etc. But there is a scarcity of private ordering or private governance, which in low and middle income countries is in effect a denial of the capacity to configure socioeconomic relationships around that technology, and as well as for regulatory competence to grow. So a positive recognition that the private ordering function, which Hillgartner calls a configuration right, would be integral to the centralizing function of the patent system and would allow us to see the persistent denial of this capacity in low and middle income countries as a sort of infantilizing of these countries, which would mean that they never really come up to speed with the kind of relationships you need to make progress in those technologies. And it's not easy to address these harms with an insider perspective on the patent system, because the patent system is not very good with dealing with harms that cannot be framed as a harm to the patent holder. So for the duration of a patent right, all and any socioeconomic arrangements have to be authorized by the patent holder. And in this view, the technology transfer that could happen is a freebie. It's a voluntary sharing of information even when there's a clear indication that this should really be a corrective mechanism for the kind of structural skewedness that results from centralizing the patent system in this way. So this brings me to what I've been working on, which is the ideational infrastructure that permeates the patent system, which I think serves as a powerful illustration of liberalism's constructed commitment to the idea of justice. The failure of the TRIPS waiver negotiations, I think, showed that we were at once a global population united but torn apart by the need for these patents. And the failure of these negotiations showed a sort of superordinate ethic of justice for patent holders. In other words, there's a robust assumption that the structure and design of these rights maximize desirable functionality or is a just structure leading to fair consequences. This assumption endures even in the face of very high cost of drugs or inadequate production of life-saving vaccines. So this ethic is aided by a form of constructivism, juridical constructivism, where the idea of the primacy of the right is accompanied by reasoning that detaches it from conceptions of the good. This foundational impulse is most clearly articulated in Rawls's idea that if we can find a regulative ideal of procedural fidelity and use it, we can then arrive at a structure of justice that is fair. And this is articulated through his contractarian thought experiment, the veil of ignorance, the original position, which then allows him to say that people's desires and aspirations are constrained from the outset by principles of justice, which specify the criteria for determining permissible ends and conceptions of the good. So loosely, drawing an analogy, once the structure of the rights in the patent system has been set out in a fair way, we must not be directed or steered by conflicting, incommensurable ideas of where we are going and what the consequences are. Given that during the pandemic and then in the controversy and subsequent failure of the TRIPS waiver negotiations, we were unable to agree on what we should aim for as a global society, the dominant discourse, in my view, fell back on a familiar structure of argumentation, a focus on existing rights and design of institutions that are nominally deemed to be just as the most legitimate way to proceed. So in our inability to agree on good outcomes, it feels clear to me that we have by default created space for the right itself to become the good end we crave, while we disagree about how to or whether we are able to get to other good ends. If you perceive the consequences of this setup as leading to systemic injustice, then in this setup, more justice is a vice, not a virtue. So it's not at all clear to me that we can acknowledge value pluralism in IP, which makes committing to primacy of justice necessary, without countenancing the consequences that result in profound structural injustice. The problem is not pluralism per se, but there's nothing to decide between them in a given instance because there is nothing prior to that apart from procedural fairness or deliberative equality. Assuming that the TRIPS framework presents a kind of just institution beset by value pluralism, what do we have to do to then make sense of this puzzle for the international patent system? So the way I feel my way through this puzzle is to go under the veil of ignorance in roles. The patent system has justice as a touchstone, right? Often mediating or justifying the decisions that are made here. But my contention in the work that I've kind of 80% of the way there is that the patent system needs to be informed by a more manifest notion of injustice that can be perceived more directly. And it is in this context that the theoretical notion of self that we bring to the idea of justice and the way it is constituted really matters. And it seems to me that the self in Rawls, who is disinterested and has this capacity to choose the principles of justice, is hamstrung. He's handicapped in this context. To perceive disadvantage requires a way to see through why or how one is disadvantaged, and then to have some capacity to understand harm without resorting to a contextual value-ridden self that Rawls did not want. While Rawls had the capacity for choice at the heart of his conception of self, there is a philosophically and epistemically prior notion that arises from the shared intuition that there can be no self without care. And this brings me to the central idea in the work, which is we know without care, infants cannot survive, or men, and it is usually men, have children to inherit their wealth or constitute community to shape their values and desires. One does not need to carry a memory of being born to know that the self would not exist but for that moment of birth. The fact that human infants are helpless for an extended period is in fact defining of our ability to reason and therefore to choose. The self in Rawls's original position is also inherently constituted by the moment of birth and the innate awareness that any sense of future is only possible in the replication of such moments. This leads us then to philosophically relevant notion of the capacity to receive care and therefore to recognize the giving of care as an element of survival that every self has, without which there can be no capacity to choose or deliberate on regulative ideals. Such a care-constituted self under the veil of ignorance remains invested in the facilitation of care while retaining Rawls's prized disinterestedness. Centralizing this care-constituted self then acknowledges the primacy of justice while also requiring us to pay attention to how we characterize and perceive harm, not simply as a consequence of the institutions that we set up, but as an upfront regulative ideal in the design of the institutions. And this deontological premise and rationale is the basis of the ethic of just care that is essential idea of the work. And in it, I work out what this update to Rawls' ideal theory might mean for a reimagined patent system in a time between pandemics. Now that I've laid out what I'm working on in outline, I would also like to say that having read patent performativity a few times now, that there is a closeness in the description of the ways in which social formations are generated by the recursive enactment of text, which in Dan's paper is about patents, that I think he might have seen my argument as flowing from a form of recursive generation of the idea of justice. And in his call, and I quote from his paper, for a transgressive reorientation of patent isolation, elitism, hierarchy, dominance, and extraction, lies a parallel to my recasting of the idea of justice that lurks just beyond the reach of conventional justificatory ideas. And that's what I would have said to him if he was here. Thank you.
We have a few months before lunch, so comments and questions. Yes.
I'm Karen Nicometto. I'm not a patent or IP scholar, but I just wanted to say both my grandfather and my father were patent holders, and I began my legal career, you're not going to believe how old I am, as a paralegal typing DuPont specifications for the patenting of Teflon around the world. So I have a long-abiding interest in patents, and Dan Burk and I joined this faculty together. And I just wanted to say, Mark and Tony, I know because Dan told me how incredibly moved he was. Is Tony here? That you two guys hold this together. Mark, your book with Dan was the first book I put on my bookshelf upstairs, and I can't say I read all of them. I read most of Dan's drafts while he was here. He read most of mine, and I may have a few words to say in the gender panel this afternoon. I learned so much from Dan over the years, as you all have, and I just wanted people to know that there are people that are not specialists in the field and have learned a great deal. And Mark and Tony, too, especially, thank you for doing this.
Comments and questions? Yeah, Ann?
I just remember a period of time when I hadn't seen Dan out of the conference circuit for a while, and I asked Mark, as well as you're going to ask, I asked Mark, where's Dan? And he said Lori had had a hip problem, and so he was home taking care of her, and that had a huge impression on me, completely unrelated to anything else. Then he just put his own ambitions and stuff on hold because Lori needed him.
I just want to say I'm very happy that the conference program was shared with Dan and that we heard his response. That makes me feel much better because I'm very sad that he's not here. So that makes me at least feel that's comforting.
Yeah.
One of the first speakers spoke about how Professor Dan was a really great father in the sense that he helped, promote the values of education with his daughter. I was wondering if you could share a little more about that because I love hearing about how, fathers encourage their daughters to reach as high as they can in academic fields.
Dan was pretty private about his private life, but he did sometimes talk about homeschooling his daughter, the decision to homeschool her, the ways in which he would try to find courses for her to take so that she was still interacting with other people. He was a humble guy. He knew the things he didn't know. There weren't a lot of them, but he did know the things he didn't know. And so he always was trying to find places for her to learn those things so that she could choose the thing that was most meaningful to her. And I don't know her, but every time he would talk about her, it was with such love and so much pride in being able to transmit to her. And I always thought I sent my kids to school. I just assume they're going to learn it all. It's not going to be what I know, but he was much more personally involved in her development. And in a way, I think all of us felt it as he would comment on our work too. I mean, it was like he was involved in everybody's development.
I do know Rain, and she's a lovely person, and I spent a fair bit of time with her growing up, and I do think, right. So there are people who homeschool because they, for ideological reasons, Dan and Laurie were not in that category at all, right? I think they homeschooled Rain because they felt like the way one learns is not by sitting in a classroom and having things dictated to you, right? The way one learns is by experiencing, and I think they really did make that happen.
I was just gonna add, just because my son is the same age, and the first time I met Dan, I for a second, I was at a college at Boston, a conference at Boston College where they housed us in the dorm, and I checked in, and there was a knock on the door, and this Dan invited me to have dinner with Laurie and his daughter the night before the conference. So that's the first time that I got to meet her, and she's just really bright, and he all kinds of experiences. She was really young and flying herself to schools to study languages. Like, I know she spoke German, but the cool thing that she got to do was travel with them because she was being homeschooled. So a lot of us, my son was at home, but I would drive him to conferences sometime. But she could keep up with people at tables because she was used to adults and things. It was really impressive that I think the people she met and like I think she got to see. It was just really neat.
I just wanted to say that I can explain why people stop confusing Mark and Dan. And it's because Mark's wife Rose, who is here, and I used to have quite similar haircut, and we have also the same body structure, and so it was like a multiple doppelganger.
Ed Cavazos still couldn't tell like the four of us
He was
apart.
pretty sure that Dan and I were Mark and Rose. But then I started doing more privacy and stopped going to IP conferences, and Rose grew her hair, and so we just, we fixed
like
it.
I'm still confused with Wendy Gordon, so there you go.
I believe we're at our lunch hour, and I'll turn it back over to Tony.
Great.
Thank you
Thank
to
you
a
very
great
much.
panel.
Turn to the panelists, please.